prosecutor say something?
No. Sorry, just another question.
Assistant Public Defender Chelsea Vergils with and on behalf of Montel Gatlin, please state your name.
My name is Montel Gatlin.
Thank you. What are we doing?
Your Honor, we are asking to set the preliminary exam in both of these cases. We do not have discovery in one case. I informed my client of that. He does not wish to waive the 21-day timeline in these cases. He asks to set preliminary exam regardless of knowing we don't have discovery on one case.
Which, yeah.
I mean, may I speak?
If you want.
I kind of don't. I don't want her to represent me.
Okay, so you don't get that choice necessarily, but why?
Because just conflict, like we had a back and forth back there in the back room. Like, I don't think she has my best interest.
Really?
Yes.
Why? Because she wouldn't do it you?
Huh?
Because why do you say that? Because I've never known Ms. Vergils not to have her client's best interest at heart. Ever.
By the things she said, this
a lot of things that she said you may have disagreed with, right?
Really all the things.
Okay, all she said. Sometimes that's a lawyer's job. Sometimes they have to give their client the hard facts of what's going on. And they have to do that they have to give them their legal interpretation of what's going on, which may not suit with what you want to happen in the world. But they just give you a steady dose of reality. So if you disagree with her legal analysis, then fine, but show me your law degree.
Right out of the gate, this hearing turns into a brutal reality check. You can already feel the tension building between the defendant and his own attorney, and Judge Simpson wastes absolutely no time stepping in to shut down what he clearly sees as misplaced confidence. The defendant is frustrated, emotional, and convinced his attorney is working against him, but the judge immediately reframes the entire situation. What makes this moment so powerful is that Judge Simpson is basically explaining something a lot of people watching courtroom hearings never fully. Defense attorneys are not there to tell clients only what they want to hear. Sometimes their job is to deliver bad news, explain risks, point 5, and recommend strategies that feel uncomfortable. And then comes the line that completely changes the energy in the room. Show me your law degree. That's the judge signaling that legal advice isn't something you override based purely on emotion. The defendant clearly wants control of the situation. 5. But the court is reminding him that legal expertise actually matters here. You can already tell this case is going to become a clash between emotion and reality. And honestly, those are the hearings that usually spiral the fastest. The question now becomes whether this defendant is willing to listen before things get even worse.
No, I'm disagreeing with her legal advice.
Okay, and you're doing that with your legal degree that you have, right?
No, she was.
Yeah, that's what I thought.
No, I don't have a legal degree, but she was trying to get me to waive things. And like I was telling her, it would kind of waive my rights to 180 days into trial, right?
She just got before me. Did you even listen to what she said? She has indicated that you don't want to waive any statutory period. So she listened to what you said. She told me that, and I was going to set these for exam. Anything else?
Yeah, I don't want her on my case.
Well, she's on your case.
Your Honor, I would ask to also address bond if possible.
Yes, you may. Hang on a second. Let me set the exams in these cases. And which case don't you have discovery on that he's trying to set it before you guys get a chance to even look at it? That makes so much sense, but go ahead.
We're using media discovery on 25 FB 1090.
On 1090?
Yes, Your Honor.
All right. Discovery on that one is not complete. I'm going to note that. Do people have their witnesses available on the 3rd? Pardon? All right. Preliminary examination in these matters will be set June 3rd, 2025. 9 a.m. That's before me, right? There's both come before me.
What just happened here is more important than it might sound at first. Judge Simpson has officially locked these cases in for preliminary examination, and notice how quickly the courtroom pivots from arguments about representation straight into bond issues. That transition matters because it tells you the court is moving this process forward regardless of the defendant's frustration with counsel. But there's another layer here that's easy to miss. The prosecution admitted discovery in one of the cases is still incomplete, yet the defendant insisted on pushing ahead anyway instead of waiving the statutory timeline. That's a risky move. Sometimes defendants believe speeding things up gives them leverage, but it can also mean moving into critical hearings without the full picture available yet. And now bond becomes the next battlefield. The defense is trying to paint Mr. Gatlin as employable, community-connected, and stable enough for reduced release conditions. But prosecutors are already preparing to frame him as both dangerous and unreliable. You can feel both sides positioning themselves before Judge Simpson even rules. Also, pay attention to the judge's demeanor throughout this exchange. He's calm, but he's also very direct. He's letting everyone know this courtroom is going to stay procedural and disciplined, no matter how emotional the arguments become.
They're in person as to bond.
Your Honor, we're asking the court to consider lowering the bond on case 25 FB 1142. Currently, it's set at $50,000. He's asking you to lower it to the same amount as his other case, 10%. Mr. Gatlin is an Ypsilanti resident. He is employed as a plumber. He at least was before he was in custody and plans to go back to that work. He's involved with his church. He plans to abide by his bond conditions. At this time, he's been in custody for 11 days now, and he is being held until May 29th on a case with Judge Washington. His sentencing is May 29th on that case. So he hopes that the bond will change at that time and that he'll be able to be released. So we're asking you to lower to something he'll be able to pay.
So he's being held on a case before Judge Washington now.
Until May 29th.
What's the proceeding on May 29th? Do we know?
Sentencing.
Sentencing. What kind of case is that? Do we know?
I don't know, Your Honor.
All right. Response from the people?
Well, Your Honor, we've asked the bond to stay the same. We think it's appropriate. He does have multiple pending cases at the same time. The case in 1090 is a stolen case. This case has concerning elements of that. He's accused of child abuse, but also fleeing police and possessing a firearm. We believe he's both a danger and a flight risk, and we think that this bond is appropriate.
All right. In this case, what I'm going to do is I'm going to deny the request for a bond reduction in this case and leave his bond in place. If something happens on the 29th, before because that'd be about 4 days before you see me. If something happens on the 29th where he's eligible for release, then you can contact my office and I'll reconsider this decision.
Thank you, Your Honor.
Thank you.
This is one of those moments where the judge delivers a denial, but still leaves the door slightly cracked open. Judge Simpson refuses to reduce the bond, and honestly, once the prosecution laid out allegations involving child abuse, fleeing police, and firearm possession all in the same argument, the odds of a bond reduction were already looking extremely slim. The court is balancing two things here: public safety and the possibility of future release conditions changing after another sentencing hearing. That's why the judge specifically references May 29th and says the defense can contact his office afterward if circumstances shift. So technically, this is a denial, but not necessarily a permanent one. What's also interesting is how quickly the courtroom tone changes compared to earlier. At the beginning, the defendant was arguing with his attorney and pushing back emotionally. But once bond discussions start, reality hits harder. Suddenly, this isn't about personality conflicts anymore. It's about custody, risk assessment, and whether the court believes release is appropriate.
Jerome Burns. Well, he's in back, right? So we might have to wait. Oh, no, there he is.
And Assistant Public Defender, not to carry out the ruling, Your Honor, on behalf of the Assistant General Instructor. Mr. Burns, say your name for the record, please.
Jerome Robert Burns.
The people's motion, this was discussed this morning regarding access to the premises.
Yes, Your Honor, I did send that motion to the Court and the Counsel. Since then, counsel and I have been speaking. It's my understanding that the apartment is actually leased to defendant's father and I believe his mother potentially. I don't believe the victim is on that lease, even though that was her home and that was her residence. I wanted to forward that information to the court. I don't believe that we are in a position to ask, for her to be able to stay in that residence since she's not on the lease and it is the defendant's father who is.
Well, I think we're absolutely in that position. I mean, that would occur, that occurs all the time.
Well,
And the problem that I have with not being able to do it, or at least forcing it to happen, is that you would have individuals that may be potentially victims of, in a domestic violence situation, where the leased premises, which is their home, is leased to somebody else. And then they can't go back there. And they didn't do anything to be sort of on the outs.
Now the hearing takes a sharp turn into something much more emotionally complicated. This is no longer just about criminal procedure. It's becoming a battle over housing, family dynamics, and alleged domestic violence consequences. The prosecution is trying to argue that the alleged victim should still have access to the residence, while the defense is focusing heavily on lease ownership and property rights. Judge Simpson immediately identifies the bigger issue. He's basically saying that if courts refuse to intervene simply because a victim's name wasn't on a lease, then countless domestic violence victims could effectively be pushed out of their homes overnight. That's a major concern in cases like this. But then the defense introduces another layer. The apartment allegedly belongs to the defendant's parents, who have lived there for years. Suddenly, the court has to untangle who legally controls the residence versus who emotionally and practically considers it home. This is where hearings become incredibly difficult because the law intersects with human relationships in messy ways. Everybody in this courtroom is arguing from a different perspective: property ownership, safety concerns, parental rights, victim access, and none of those issues are simple.
Judge, if I may, I think there's a little bit more information that the court should have. My understanding, my client's father is here present, and he was the one that was able to update us on what was happening. The apartment is leased to him and his wife. That has been their home for the past 9 years.
Who's home?
Father and mother, not defendant and complaining witness.
Okay.
Yes, so it's leased to them, but that's their home. And my client and his wife were living with them at the time. They still live in the home currently.
Okay.
And my understanding as well, and it states it in the report, before this incident even occurred, the complaining witness had left the home. She had already moved out of the home. I know that the original allegation or issue was that there was the locks in the home were changed.
Yes, that's what I heard.
That is correct.
Why I set the hearing.
I spoke with Dad about that, and Dad said, yes, I did change the locks because she had since moved out the home probably about a month before then. And later he found out that the complaining witness was entering the home with the keys that she did have while he wasn't home, moving things around. And he stated that he felt it was necessary to change the locks because she was no longer living there.
Your Honor, my understanding is that the victim left because of the physical abuse and fear by the defendant. So she left and sought a safe place for her and the child. So that part's true. My understanding is the same, that she left, however, under those conditions, and I think that is an important addition. But going back to why I don't believe we cannot exclude defendant's father from a place where he's leasing, of course. So in regards to that matter, we'll just ask for there to be a civil standby so she still has belongings there. I of course ask that none of her belongings be touched by the defendant's family and that they cooperate with law enforcement to allow her to come and retrieve those.
At this point, the prosecution is carefully building a much broader picture for the court. Notice how the argument is no longer just about belongings or locks being changed. The prosecutor is gradually reframing the entire situation around vulnerability and control. The court is hearing allegations involving a mother with a medically fragile child, unstable housing circumstances, lack of transportation, and fear connected to alleged abuse. That combination dramatically changes how these arguments land emotionally inside a courtroom. And here's something viewers should pay attention to. Prosecutors often use these hearings to establish patterns, not just isolated facts. Every detail being introduced here, the changed locks, the child's medical condition, the transportation issue, is helping create a larger narrative about dependency and hardship. Meanwhile, the defense is trying to keep everything grounded in technical boundaries. Who owns the property? Who leased the apartment? What legally belongs to whom? But emotionally, those arguments can become very difficult once a child with serious medical needs enters the conversation.
There's also a matter of the vehicle. So at this point, the concern I have for this victim, and more so for the child, quite frank, is that this child has very serious medical needs. This sexual assault took place at Mott's Children's Hospital. While their child was in the hospital, the defendant sexually assaulted the victim. This victim is in fear of the defendant. She, as far as I know, does not have a home to go to. She, as far as I know, does not have a vehicle for transportation. And we're not just talking about going to get groceries. She has a child who has serious medical needs. And so it's concerning to me that she's not able to take that child where that child needs to go for medical needs and other basic necessities. So she's, of course, in a very, very bad situation. The two of them are married. There is a car that is, from what I understand, just sitting there, and there are car keys that go to that car. Counsel and I have been speaking throughout the day, and I thought we had an agreement that the victim could use the car since it's just sitting there, and she desperately needs it for they have in common, to be able to do what she needs to do for that child. Since then, I learned that the defendant is not agreeing to that. My understanding is that he has some concerns about the condition of the car. And I'll let Ms. Akuri speak to that. But again, my more immediate concern is this child right now. I'm not suggesting we should talk about the ownership of the car, but I don't understand why this victim cannot have access to their joint car to transport the child if she needs to.
And Your Honor, I did have an opportunity to speak with my client. Initially, the client's father, again, was the one who was able to facilitate. He did inform me where the vehicle is, that there are keys to the vehicle. And speaking, he doesn't have permission to give them over, obviously. I spoke with my client. He reports that there is front end, it's not damage, but there are front end issues with the vehicle. It's a work truck. It's a very large truck. It's a Chevy equivalent to, I think, a Ford 350. It doesn't have any of the additional enhancements, but he said it's a very large truck. All of his work stuff is in there. He's concerned.
His work, dad's or
my client, Your Honor.
This exchange becomes incredibly revealing because now the fight centers around the vehicle, and both sides are framing the exact same object in 5 completely different ways. To the prosecution, the truck represents access, independence, Fight 5, and the ability for a mother to care for a medically vulnerable child. To the defense, it's being framed as unsafe, mechanically unreliable. 5, uninsured for the alleged victim, and tied directly to the defendant's work and livelihood. And honestly, this is where courtroom hearings become fascinating because the judge isn't just listening to facts. He's evaluating credibility, priorities, 5, and underlying motivations. The prosecution is emphasizing urgency and immediate need. The defense is emphasizing liability, safety, and ownership concerns. But listen carefully to how Judge Simpson reacts throughout this entire discussion. He seems increasingly focused on one central issue: whether practical obstacles are being used to limit the victim's ability to function independently. That's why the tone starts getting sharper. The court is moving beyond the mechanics of the truck itself and into broader questions about power, dependency, and parental responsibility.
This is his vehicle. He reports that this vehicle was his prior to. He does not feel that it's safe to marriage. I apologize, because the people indicated that this is like joint marital property or something to that effect. But this is a work van or truck that he has been using for his construction business. I do not think, when she left the home, she left without the truck, Judge. The truck has only become an issue now. And I don't really understand how, if there is an emergency, the truck would really be of any help, because I think 911 would be the more plausible way to go if there's a medical emergency with the sick child. Back to the truck though, Judge. The truck, we don't know.
I guess I don't get this. I mean, I'll let you finish.
Sure.
But these are two people, married and or not married, who have a child together
Correct.
that has special needs and may require medical care.
Mm-hmm.
For whatever reason, the big people don't get along now. And what I'm hearing you say is that as a father, I'm not going to make sure that the other caregiver of this child at least has some ability to get the child where it needs to go. That's what I'm hearing you say.
That's not necessarily what we're saying, Judge. I think that my client, again, with the mechanical issues with the vehicle, he indicated that it's not safe for her to drive. So it's not the safest vehicle to turn to if you needed anything in regards to transportation. And also, if he was in the process of getting the condition or the issue of the car fixed, and he hasn't been able to do that. So it's possible that driving it any further would possibly make it, put the car in a worse condition mechanically.
The defense is trying very hard here to keep the discussion focused on practical concerns with the truck, but Judge Simpson clearly isn't viewing this as just a mechanical issue anymore. From the court's perspective, the larger question is becoming whether a mother caring for a sick child has meaningful access to transportation. And this is where the emotional contrast in the courtroom becomes impossible to ignore. The prosecution keeps returning to urgency and hardship. The defense keeps returning to technical limitations and concerns about the condition of the vehicle. Neither side is technically abandoning logic, but they are arguing from completely different priorities. That's why the tension keeps escalating. Also notice something subtle. Judge Simpson repeatedly redirects the conversation toward responsibility and common sense rather than strict ownership. Disputes. He appears increasingly frustrated by explanations that, in his view, fail to address the practical reality facing the alleged victim and child. This is one of those hearings where the emotional undertone starts influencing the momentum of the room. Once a judge begins seeing one side as overly focused on obstacles instead of solutions, the dynamic can shift fast. And honestly, you can almost feel the judge preparing to step in more aggressively the longer this argument continues.
What else did you?
So, Your Honor, if I may.
Yeah.
I'm not here to argue the condition of the car. Just, I understand this is all coming to the defendant. Again, and I want to be very clear that the victim has not asked for access to the car. I reviewed the case. I found that she does not have any transportation. And based on my experience, that is concerning to me when there is a sick child. How that car may be affected, potentially or not, by her driving it to provide for this sick child doesn't really matter. That is not what matters here today. This is an urgent situation. It's bad enough that she is homeless because of the physical assault she endured while having a sick child, dependent child. The least we can do is give her access to the car for those purposes, and then they can work it out later. I'm not worried about whatever's going on between the two of them. She needs to be able to have some transportation. She has a small child that is sick, and she needs some help.
And Your Honor, my client, he did raise his hand. He just wants the court to understand that he's not trying to keep the vehicle from them. He says it's not a safe car to drive at all. That normally when the child has appointments, the state provides transportation for the child to get to and from his appointments. He has indicated to me that he has transported the child in their vehicle previously, but the wife does not normally drive that vehicle. It's not a vehicle that she's used to driving. She doesn't drive it normally. It's his work truck. And aside from...
So she's incapable of handling what would be...
No, I don't know.
This may be one of the most uncomfortable stretches of the entire hearing because the discussion starts exposing deeply personal dynamics in real... Judge Simpson is no longer simply asking about the truck itself. He's questioning the assumptions surrounding the alleged victim's independence. And Ability to make decisions. The defense attorney appears cautious here, repeatedly emphasizes uncertainty, not knowing whether she's insured, not knowing the status of her license, not knowing her driving habits. But the judge is hearing something else underneath all of that. To Judge Simpson, the issue seems bigger than transportation. He appears concerned about whether the alleged victim's autonomy is effectively being filtered through the defendant and his father. Then the insurance explanation lands in a way that changes the energy of the room completely. Once the discussion turns into why she allegedly wasn't added to insurance due to cost. You can sense the judge becoming increasingly skeptical and frustrated. And viewers, this is where courtroom perception becomes critical. Even if explanations are legally or financially reasonable, they can sound very different emotionally when placed inside a domestic violence context involving a sick child.
I don't know if she's licensed. I don't know if she's insured on that vehicle. I don't know. She's not. They're just
Not insured?
she's not insured on the vehicle, Judge, according to what my client just told me.
How does that happen?
It's a joint insurance. So if I would have added her to the insurance, then she'd be able to legally drive that vehicle. If she's not added to the insurance, she legally cannot drive that vehicle.
That's not what he's asking you. Why did he
Your wife?
Do it.
why did he
Really?
insure her on the vehicle?
And it cost way too much money having her insured on that vehicle.
And that's my understanding, Your Honor.
Was there a vehicle she was insured on?
When her dad had a vehicle for her, she was insured on that and had received a.
Where's that vehicle then?
That was 7 years ago, sir.
And that's
So for 7 years, she hasn't been able to drive?
She's able to drive. She just hasn't. She chose not to.
And that's kind of what Dad told me, Your Honor. Dad just says he doesn't really know her to drive. She's not one that drives normally. She's usually at the house, or they use the transportation provided by the state whenever they needed to take the child to the vehicle. Other than that, my client was the one who would do the majority of the driving.
Your Honor, what we're seeing, I'm sorry, this is a perfect example of the worst domestic violence dynamic you could possibly imagine. The fact that the defendant and the defendant's father are deciding whether or not this victim can drive a vehicle, when she can drive, how can she.
The prosecutor just delivered what may be the most emotionally charged argument of the hearing so far. Calling this the perfect example of the worst domestic violence dynamic is an extremely strong statement, and it instantly reframes the entire courtroom discussion. Now the issue isn't just transportation anymore. The prosecution is arguing that the alleged victim's freedom and independence are effectively being filtered through decisions made by the defendant and his family. That accusation dramatically raises the stakes. The defense continues trying to redirect the conversation back toward practical explanations, whether she normally drives, whether she has work obligations, whether the vehicle is safe. But Judge Simpson appears increasingly focused on something much simpler. She's an adult capable of making her own 5 choices. And honestly, the judge's reaction here tells you everything about where this hearing is heading. Once he starts openly pushing back against what he sees as paternalistic decision-making, the momentum clearly shifts toward granting access. Let me ask you this. Do you think the court should prioritize strict property and insurance concerns in a situation like this? A 5, or should immediate family and medical needs outweigh those issues temporarily? Cases like this divide people fast because they sit right at the intersection of law, safety, and personal responsibility.
I mean, this is.
I don't think that that's what we're saying, Judge. We're just stating facts that he stated that she had a vehicle at one point. She no longer has a vehicle. If she doesn't have a job to go to and she doesn't have any other need to drive, all we're stating is that she does not drive normally. The bottom line on our position, Your Honor, is my client indicates that the vehicle is not safe. Now we've concluded from him that she's not insured on the vehicle. I don't know the status of her driver's license. So honestly, I think that this is a family law issue. I don't think that this pertains to our case at all. She left the home previously before this case happened.
I want the keys turned over.
You want the keys? No worries, Your Honor.
I want her given access to the truck. She can then make, I'm assuming she's a grown woman, so she can make her own decision as to whether or not she wishes to drive that truck.
Okay.
She can also make her own inquiries as to the insurance that's available on that truck. And the like. She can even take it to a mechanic and have them look at it as to its roadworthiness. But geez, she's grown and she can make her own decisions and doesn't have to have defendant dad make those decisions for her.
And there it is, the defining statement of the hearing. Judge Simpson has now made his position unmistakably clear. The court is no longer entertaining the idea that other people should decide whether this woman can access transportation. The judge cuts straight through the layered explanations and reframes the issue in plain language. She's an adult. Part 5, and adults make their own decisions. That moment matters because judges often reveal their entire reasoning philosophy in a single sentence. Here, Judge Simpson is emphasizing autonomy over gatekeeping. He's essentially saying that concerns about insurance, vehicle condition, or family opinions do not outweigh her ability to independently evaluate those risks herself. And notice how quickly the courtroom starts moving toward logistics immediately afterward. Once the judge makes up his mind, the conversation transitions from debate into execution. Who has the keys? Where will they go? And how will they be transferred? That's classic courtroom momentum. Once a ruling direction becomes clear, prolonged argument usually collapses fast.
So how are we going to get these keys to her?
Dad says he has the keys. It's not with him right now, but I mean, previously, again.
Them to the public defender's office can get them to the prosecutor's office can get them to the victim. All right. What do we then need to do on this case?
So, Your Honor, initially we were asking for the adjournment. There was a little bit more discovery or investigation, I would say, on our end that we needed to complete before we decided which way to go.
About the 5th or the 12th, Counsel?
I didn't hear you, Your Honor.
5th or the 12th?
Let's do the.
I mean, he's in custody, that's why I'm asking.
Let's do the 5th, Judge, that's fine.
June 5th, 2025. 9 a.m. or as your invite indicate, bond will continue.
Thank you, Judge.
What an incredibly layered hearing from start to finish. We began with a defendant openly challenging his own attorney and questioning legal advice. And by the end, the courtroom had shifted into emotionally charged arguments involving domestic violence allegations, housing disputes, I'm 5, transportation access, and the needs of a medically vulnerable child. Throughout the hearing, Judge Simpson consistently tried to pull the discussion back toward practical reality. Whether addressing the defendant's complaints about counsel, 5 denying the bond reduction request, or ultimately pushing for access to the truck keys, the judge repeatedly focused on responsibility, 5, accountability, and decision-making grounded in common sense rather than emotional escalation. The bond ruling remained in place because the court viewed the allegations and surrounding circumstances as too serious to justify immediate release. 5 changes, but arguably the most memorable part of this hearing was the judge's stance on autonomy and transportation access. His repeated emphasis that the alleged victim is grown and capable of making her own decisions became the defining theme of the proceeding. Cases like this show how courtroom hearings often become about far more than criminal charges alone. They reveal family dynamics, power struggles, financial realities, and emotional fractures all unfolding live in front of the court. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.